Good morning, Mr. McElhaney.
Good morning, Your Honor. Rocky McElhaney and Leah Yoder for the appellant Tammala Thompson. I'd like to reserve 3 minutes, please.
3 minutes, yes, sir.
Yes, Your Honor, thank you. May it please the court, we're here today to really, in broad scope, ask the court to re-examine and rethink the judicial interpretation of this trust statute, Tennessee Recreational Use Statute, which has been broadened through these appellant decisions we submit beyond what the intent was of the framer of the legislation. Our case is here, and let me say this, we think we've given you an argument of first impression by which we can start to curtail some of the broadening of the statute. Real people are getting hurt on defective and dangerous conditions on these properties and are not able to seek redress. We submit the public policy under 9-8 is to hold the state accountable for these dangerous conditions. So Tammala Thompson.
I'm sorry, Mr. McElhaney. Did you say how many minutes you wanted to reserve?
3, Your Honor.
Okay, thank you.
Thank you, Your Honor.
I was a little asleep at the wheel there.
It's okay. Tammala Thompson rented a campsite at Cedar, and she went there. It's a state park. We agree and concede it's owned by the state, so prong 1 of the analysis that we have a problem with that. It's a paved area. It provides a public bathroom. This is more akin to glamping than backpacking in the woods, right? That's camping. When you put the tent on your back, you go up in the woods, you're walking around. This is at a paved park where you drive an RV in and you hook it to the thing and you use a bathroom and you cook in your camper and stuff, right? So she goes to the restroom, walking on pavement into a public facility. She uses a public bathroom, and she's walking back and she trips over the uneven sidewalk road. There's pictures of that in the statute. Now, what we think is a critical fact if the court wanted to just remand is the fact that paragraph 83 and 84 of the amended complaint alleges that a sidewalk is an improvement and a sidewalk is not a structure. That's an allegation of fact that has not been determined, and if you take all allegations in a motion to dismiss as true, then a sidewalk is an improvement. The definitions of land and premises in 701A create the opportunity for this issue of first impression to be an avenue for the court to find in favor of the claimant and to find as a matter of law that a sidewalk is not a building or structure. Land and premises in 701 and in 101A and B includes structures and building. In 701 and 101, 101C, it does not include building or structure, but includes the word improvement. The legislature has to know by judicial construction, which I'm not going to spend a lot of time on because this court knows it better than I do. The legislature knows these words are different. They use one word or two, building and structure, in A and B, and improvement in C. Now, we recognize that C applies to a person's residence, okay, and not a public land or a land that might be private but used for hunting or fishing by residents. But the point is, they use different terms. And if I could just point out, they give some examples. The legislature gives some examples in 101C of what an improvement is. And in those examples, they include a swimming pool. So I submit, if our argument holds water, that the trust does not grant immunity for improvements, then the Beckham case would go a different way. The Beckham case involved the diving board at the swimming pool. the legislature tells us in C that a swimming pool is an improvement. They enumerated it.
What if you have a sidewalk that leads to the swimming pool, and the concrete sidewalk connects, is part of the swimming pool? When do you say the sidewalk is not part of the swimming pool, and when is it?
That's a great question, Your Honor. I would say under 101C, neither are structures and buildings. That a pool is an improvement built to utilize the property in a more, the definition of improvement that we cited from Black's Law Dictionary is to enhance and improve the use of the land. I would submit under the 101C, both of those are improvements. And so you wouldn't get to the analysis of when does it start and stop if
even though swimming pool is listed as an improvement. I thought your argument was that the sidewalk is not an improvement.
The sidewalk is an improvement. It's not a building or structure.
Okay, gotcha. Okay.
It's not a building or structure as defined under land and premises on 101A and B.
Right, okay.
It is exempt as an improvement. And we submit that had the legislature wanted improvements to be included in the definition of land or premises, that they could have inserted that word in A and B, but did not. And so when you take the
definitional section of this statute is interesting, and I'm wondering, as a threshold matter, should we be focusing on 701B as opposed to 701A? I know the language is almost identical, yes, but the distinction is B deals with it's owned by a governmental entity.
Yes.
So just as a threshold matter, are we looking at B rather than A?
I think we are, Judge.
Okay.
I think we are.
So let me ask you this question. One of the arguments the state makes is well, land and premises is also defined as real estate. And real estate may include fixtures. Wouldn't a sidewalk count as a fixture?
I don't think so, Your Honor. Here's why. The legislature didn't say fixture, right? So what the
But they do say real estate, and real estate normally incorporates fixtures.
But a sidewalk isn't a fixture to a building. So you take a fixture, you build a back porch onto your house, you put a cabinet, a man-made cabinet inside your house, right? That becomes a fixture. If we look at the definition of fixture, a sidewalk doesn't affix to the real property. It affixes to the land, and it can be removed without damaging the property, which is also a part of the definition of improvement. Can it be removed without damaging the property? And we submit it can be. I mean, I think the court can take judicial notice that sidewalks are busted up all the time, and it doesn't damage the land. This could be a question of fact to send the case back on as well. But I don't think it's a fixture. If the legislator wanted it to be a fixture, they should have said it's a fixture. Now, back to the state's argument really quickly, Judge. They want the court to read in that real estate means improvement. But you can't add words. That'd be adding a word to the statute. The legislature used the word improvement in C, but not in B. So if they wanted real estate to include improvement, they would have put it there.
So just getting past that argument, then let's assume for the sake of argument then real estate does not include necessarily fixtures, or sidewalk is not a fixture, as you would argue. It does include building and structures. And I'm trying to determine, if we accept your argument, what's the distinction between a building and structure? After all, the definition you cite in Black's for structures says a building is a structure. So does that mean building and structure really is the same word? It doesn't add anything to the definition at all? And if so, how can that be?
I think you're on to the point, Your Honor. The legislature chose to use building or structure. So what's a building? Maybe they meant a building is a high-rise and a structure is a barn, right? Maybe because you be out hunting and fishing, you can encounter a barn, you can encounter a well.
But in Black's, that would also mean it's a building. It describes the same thing.
I believe you're right. I would argue that a building and a structure are the same thing, and the legislature chose to put two words in that effectively mean the same thing. I think a factual interpretation in some hypothetical case could be that a well on a property or a shed on the property could be a structure because it's not as complex as a house or something different. I think some factual interpretation, but I don't think the words are different. I don't think the words are different.
So under your argument, the case of Matthews v. State would have been wrongly decided.
I believe so. Matthews was after trial. Matthews does involve, I've got some notes on Matthews, Your Honor, give me 1 second, if it please the court. Matthews, the main thing about Matthews that I submit is that while the facts are similar, State Park sidewalk injury, it was after trial where findings of fact were made. And this statutory construction statute was not raised in Matthews. You read the opinion, they weren't arguing about the difference between improvement and building a structure. I'm down to 1:15. I do want to say this, that I believe going to the restroom is a human function. It's a human bodily function that is not a recreational activity. Now, I know the law says once you enter the premises, you're on a recreational activity. I think that's wrong. I think that's bad law. And that's just McElhaney. I think it's bad law. Not everything you do at a state park is recreational. Going to the bathroom is not recreational. And we submit you should think about changing that. We got all appellant cases. There's no Supreme Court cases except Parent, which overturned a motion to dismiss and sent back for findings of fact, right? So the final thing I want to say is that all the cases cited by the state are at a different level in the case process than we're at. Parent, which is the only Tennessee Supreme Court case we have, upheld a Court of Appeals reversal on a motion to dismiss. Then you got Morgan, Schneider, Bates, Beckham, Cagle, McCorkle, Gordon, or Costner are all at the summary judgment or trial stage before the findings are made and the appeals are taken. So we submit none of those cases are where we are today on a motion to dismiss where you take everything as true. We would like the court, and the public policy argument is the original statute is clear. It's a hunting and fishing statute. They called it a sportsman statute, right? Sportsman statute. We gave you that legislative history. And once you find that there is some ambiguity or difference in those words, and what does the legislator mean, then you can look back at the historical interpretations and the prior versions of the statute. You're permitted to do that. And so we submit that you do that. Finally, where does this end? If we keep judicially broadening the statute, where does it end? When the south end of Neyland Stadium collapses and kills 500 people, is that recreational activity? Watching a football game? They paid $400 for a ticket. What about a little leaguer in a dugout at a baseball park where the roof of the baseball dugout collapses and causes a brain injury? He's playing baseball at a public facility. Is that recreational? Do we let these landowners buy with these dangerous conditions? I submit we should not do that. And we submit that you should find that an improvement is not a building or structure, and that as a matter of law, the trust does not apply to this case. The alternative, we ask the court to remand it for findings of fact.
All right. Thank you, Mr. McElhaney. You'll have 3 minutes for rebuttal. We'll hear from the general. Good morning, General Donica.
Good morning, Your Honors, and may it please the court. My name is Eric Donica with the Attorney General's Office, and I represent the state. This court has explained that the operation of the recreational use statute is straightforward, and it should stay that way. To ensure that it does, the court should affirm the Claims Commission's dismissal of this case under the recreational use statute for two overall reasons. The first is that Cedars of Lebanon State Park simply is land under the statute's definition. And second, the court should not delve into issues of legislative history or public policy. Judge Clement, when discussing the Beckham case, I believe you asked a question about when is the sidewalk connected to the pool, and Judge McBrayer, you asked about a sidewalk being a fixture of land, and I think both of those questions get exactly to the heart of this matter, which is that Cedars of Lebanon is land, and the sidewalk that's on it is part of the land. It's an integral part of the land. There is no separation between the sidewalk and Cedars of Lebanon State Park itself. The sidewalk is an integral part of the land.
When or maybe why then is it necessary to define structures and improvements?
Your Honor, I don't believe that it is necessary. I think getting into those definitional issues actually misses the point here. And instead, all that matters is Cedars of Lebanon State Park with the sidewalk overall is land. And the Matthews case mentions, and the Costner case does as well, that the statute applies as soon as you enter land. So even if there is some sort of distinction here between the state park itself and the sidewalk, all that matters is that Ms. Thompson entered the park overall itself.
So does subpart C add anything to the context of the definitional section at all?
It doesn't, Your Honor, and the reason is, as Mr. McElhaney conceded, it has to do with primary residence. And the reason that improvement isn't helpful there is because it is excluding what is considered land, and it's mentioning particular improvements that are excluded as land. It is not talking about what kind of improvement might be considered land under subsection A. And I think what might explain this as straightforwardly as possible is the nature of the claim here. It is a claim for a dangerous condition on state-controlled real property. And real property is part of the definition of land under the statute. How can you bring a claim that depends on real property being at issue, yet also argue that it's not real property? And that itself shows just how straightforward this is and how straightforward the statute is meant to be.
So this statute is really incredibly broad, right?
It is, Your Honor, and it's supposed to be, and the argument from Ms. Thompson is that that's a problem, but whether it's a problem is a question for the legislature. It can decide these public policy issues. It can create a broad statute that is intended to give great protections to landowners. The point of doing so is to encourage landowners to allow people to engage in recreation on their land. It ultimately is a benefit to the public as a whole to be able to do that. There are, of course, the individuals who do get hurt that the statute doesn't benefit, but the legislature is allowed to focus on one side of public policy issues. So the fact that it's a broad statute is not a problem. And even if the sidewalk is separate, deemed separate from the park overall itself, I think I mentioned Matthews already. Matthews simply says it's an immaterial distinction because all that matters is you enter land and then the statute applies, and that's what happened here. And in discussing the cases that the state has cited, Mr. McElhaney indicated that those were either after trial or at the summary judgment stage. The reason that that is immaterial here is that it is undisputed that there was a sidewalk that Ms. Thompson tripped on, and that's the essence of this appeal. The only thing that matters for the purposes of this appeal is that she fell on a sidewalk. At that point, whether that fits the definition of land is a question of law. It isn't a question of fact anymore. So that distinction is an irrelevant one. And the cases that the state has cited show that where somebody does injure themselves once they're on land or how they're injured is immaterial as well. The staircase at issue in the Bates case, I believe a staircase might be considered an improvement, and the court didn't seem to have an issue with that. Same with the Beckham case, a diving board would be an improvement. All that mattered was that the plaintiff had entered a public pool area. The Cagle case, all that mattered there was that a child who was injured climbing a battlefield cannon had entered the Shiloh Military Park, historical park, I believe it was. There was the fact that the child didn't injure himself on land itself, instead it was a cannon. That did not matter for purposes of the recreational use statute. As for these public policy and legislative history issues, I've already mentioned that part of the public policy argument is the allegation that it's too broad and the question of where does it end. But the breadth is a question for the legislature. It was entitled to make this public policy decision. And as for legislative history, Mr. McElhaney argued that the statute initially was supposed to be a sportsman's bill for hunting and fishing. But in Ms. Thompson's brief, it concedes that the statute has been amended over time, and the current version of the statute is what reflects the intent, which was to broaden it beyond a hunter's and fisherman's bill.
Mr. McElhaney indicated that he didn't think the bathroom was a recreational use. Does that matter in your analysis?
I disagree that it doesn't count as a recreational activity. I will note that that issue was conceded below, or maybe it may have been actually in the brief here, saying that I think the word was even assuming that there was a recreational activity. Then it's all about the sidewalk being an improvement. So I think that counts as a concession, but even if it doesn't, it's still a recreational activity, mostly because of what Matthews and Costner say about the fact that you just have to be on land for the recreational use statute to apply, even if you are not actually doing the activity at the time you're injured. And I think there's another case that illustrates that point that I want to mention, which is the Costner case uses the phrase somebody engaged or intended to engage in a recreational activity. So that supports the idea that all that matters is that you've just entered the land with the intent to engage in a recreational activity, even if you're not actually engaging in it yet. And the Waterhouse versus Tennessee Valley Authority case also uses the word intent. A plaintiff was on his or her way to a picnic area but hadn't gotten there yet, hadn't started picnicking, but it was enough that the plaintiff had the intention of picnicking. And if we start trying to deviate from that case law and start trying to parse out when somebody exactly was doing the precise activity they were there for, that's not what the intent of the statute is. It's supposed to offer broad protections. It's not supposed to be diving into the nuances of these issues. I think perhaps a good example would be if somebody, we're talking about using the bathroom here, if somebody's hiking on a trail and deviates from the trail to do that bodily natural function, are they suddenly not hiking anymore during that one particular small window? So ultimately, these definitional attempts to distinguish one part of land from the land itself. It ultimately is immaterial here. Ms. Thompson had entered the park, and that's all Matthews requires, and then she injured herself on the sidewalk. And for that reason, that's the overall reason that this court should affirm the Claims Commission's dismissal. Thank you.
Thank you, General Donica. Mr. McElhaney?
May it please the court. This entering on the land and you're always in a recreation, I submit that's absurd. That the state's argument is absurd, and here's why. Let's say Ms. Thompson didn't go to the restroom, but she was sexually assaulted in her camper. And the allegation is negligent security on behalf of the state park. Is she engaged in recreational activity when she's sexually assaulted? How far are we going to take this? We understand that it's up to the legislature to amend the statute. We get that. We're not asking you to amend the statute. We're asking you to interpret the statute, just like the Eastern section interpreted the golf course case to say that playing golf and hitting a golf ball toward the green is similar to target practice. We submit that is too far to say that golf is hiking and that riding in a golf cart is the same as an off-road vehicle. That's a judicial interpretation of the statute. That's what we're asking this court to do. And we provided you with a framework on the definitions. Neither improvement nor structure or building are defined in the statute. Therefore, this court's capable of finding that definition. To argue that it's real property in anything on the real property, if that was the case, why would the legislature not just say real property? Why do they go forward and define it and to include buildings and structures? And then in C, not say buildings and structures, just improvements. It's clear they knew the difference. And they included swimming pool and tennis court. Your Honor, I would submit a tennis court is made of the same material that a sidewalk is made of. If the legislator tells us that a tennis court is an improvement, then we submit that a sidewalk is an improvement. There's no difference in them except what you do on them. You walk on a tennis court, you walk on a sidewalk, right? So we submit that interpretation should result in a reversal and a finding that this is applicable. The staircase case, we submit it is an improvement, but this this statutory construction argument, which we submit as first impression, was not raised. If this argument had been raised in the staircase case, could have been a different result, and should have been, frankly. Back to one final thing, there is, we submit, a factual issue with whether the sidewalk is an improvement. 83 and 84 of the amended complaint makes that allegation, and we submit that would require a development of a record to dispute or overcome that allegation, which must be taken as true. But we believe this court can find under the definitions as a matter of law, a sidewalk is not a building or structure, and find that the trust does not apply to the situation. She didn't injure herself, as the general said. She tripped over a defective, unlevel sidewalk where the pavement was poured that way by the state. So unless there's questions from the court, that's all that I have.
Hearing none, thank you, Mr. McElhaney and General Donica, for your arguments. We will take this case under advisement. Call the next case, please.